Hey everybody, I'm Judy, the YouTube lawyer. Today I have our special guest, Dan Dacquisto, who is willing to help me read the additional documents from the custody relocation case involving Wendi Adelson and Dan Markel. So let's welcome Dawn for the first time to the stream. Everybody be nice and give her compliments so she'll come back. Hi, Dawn.
Be nice. Don't bully me. Hi,
Yeah.
everyone. It's
Yeah.
fun. It's fun to be here. I like chatting with everybody in the chat box, so I won't be chatting today.
Yeah, and I did notice all your nice comments, and it sounds like you really know the Markel case very well too, right?
Yeah, I watched the whole trial and some parts more than once. I'm not like Tilo,
Tony.
and I didn't watch it like 15 times, but I very interested in there's so many different aspects to it, like this what we're talking about today, and it's insane, like it's just insane, complex. But yeah, it'd be really nice to see justice done for the Markel family. I really
Yeah.
feel for them. Yeah.
Yes, exactly. So let's get started. So we are continuing on with Wendi Adelson's memorandum of facts and law in support of her petition. So I'll go ahead and read the first page and we'll just alternate. So thanks again, Dawn. I really appreciate you taking the time to do this.
Oh, you
Okay.
bet.
So this is in the Circuit Court of the Second Judicial Circuit in and for Leon County, Florida, Family Law Division, in re the marriage of Wendi Adelson, petitioner/wife, and Daniel Markel, respondent/husband. It's titled Wife's Memorandum of Facts and Law in support of her petition to relocate to Coral Springs, Florida, with the minor children. The wife, Wendi Adelson, files this memorandum of facts and law in support of her petition to relocate with the minor children and would state, A, facts of the case. The parties were married in 2006 in Boca Raton, Florida. The petition for dissolution of marriage was filed in 2012, making this a 6-year marriage. During the course of this short-term marriage, the parties have resided in Miami, Washington, D.C., and Tallahassee. The wife is from Coral Springs, and her entire immediate family resides in the South Florida area. The husband is from Canada, and his family remains in Canada. The husband is not a United States citizen. Neither party has family in Tallahassee.
Both parties are currently law professors at Florida State University. The husband is a tenured professor, while the wife is a clinical non-tenure track professor. The parties have 2 small children, ages 2 and 3. Although the wife acknowledges the great love that both parties have for the children, she submits that she has been the primary parent of the boys up until the date of filing the petition for dissolution of marriage. The husband has traveled a great deal during the course of the marriage, attending conferences and giving lectures. Although the husband did take some time off after the birth of the children, he traveled to Israel and New York, as well as other conferences during this time, and also published legal articles. Much of the parenting prior to the petition was the primary responsibility of the wife. The husband has consistently expressed to the wife that he desires to move to a larger metropolitan area, which has a larger Jewish community than Tallahassee. During the course of the parties' marriage, he has continued to attempt to obtain professorship elsewhere. The parties have expressed a desire to relocate to the South Florida area throughout the marriage. The husband has indicated that he most definitely would like to move before the boys reach bar mitzvah age, which is around 13 years old. The wife has been very unhappy in the marriage and filed her petition for dissolution of marriage in August 2012. The husband continues to characterize this as an abandonment of the family. At no time has the wife abandoned the children. She is divorcing the husband due to her unhappiness with him and the marriage, and she only moved out of the home because she knew that the husband would not. The husband's statement of abandonment are unfounded and not supported by fact or law. He simply is having difficulty accepting her decision. In fact, he is having so much difficulty that He has told several of her colleagues and friends that she must have mental health issues. He has also told them that she has stolen money from him when she took her one half of the joint bank account.
The husband's position at the law school is a considerably different one than the wife's. He earns almost $180,000 per year as a full-time tenured professor. Until 2 months ago, the wife was a, quote, visiting professor, unquote, with a non-permanent position. The husband has often told the wife that her position at the law school was only due to him. Since the filing of the petition and the separation of the parties, the wife has been offered a position at a private law firm in South Florida, offering more money and considerably more opportunity for advancement than her current tenuous position. The wife would like to relocate with the minor children because this position is very advantageous. Her family is in South Florida. It was always the intent of the parties to try to move back to South Florida. The husband has made it difficult for the wife with her colleagues at her current position due to his statements and actions. And the husband's intent is to relocate to a larger area at some point, so the wife is merely stuck in Tallahassee until the husband decides that the time is right for him to leave. The husband has family from Canada that spends time every year in South Florida and has a flexible job so that he can travel to South Florida regularly to see the children. The children are very close to the wife's extended family, and this move is in their best interest. B. Law in this case. The relocation statute in its present form is relatively new, and not much case law interpreting it has been decided at this point. It appears from the little case law that has been promulgated that each decision is fact-specific. Contrary to the husband's assertions in his memorandum of law, several recent cases have either affirmed a relocation or reversed a denial of relocation. Also, it is important to note a distinction in the status of the cases that the husband glosses over. This is an initial dissolution of marriage in which no parenting plan has been established.
This is not a change from any established visitation or parenting schedule. It is the establishment of a parenting schedule, including a consideration for relocation. The husband submits that no recent cases have allowed relocation when the parties have an equal time-sharing arrangement. First of all, no arrangement exists currently. The wife is requesting that this court establish a time-sharing arrangement, both if she is allowed to relocate with the minor children and if she is not allowed to do so. She does not believe that a 50-50 time-sharing arrangement is in the children's best interest. The husband travels a great deal and has not been the primary caretaker of the children. The parties have been unable during the pendency of this proceeding to agree on a set time sharing of the children. Due to the husband's intransigence in this regard, the wife has acquiesced more or less to his demands for time sharing. The wife does not believe that this has been in the best interest of the children and is merely to placate the husband. He is so determined to have 50-50 time sharing that he insists that the days change every week to work with his travel schedule. And if the wife requests even an hour more, he insists that his hour be made up somewhere. His schedule has not allowed for a consistent and set schedule for the children. This is not in their best interest and is merely in the interest of the husband. The case law indicates that the entire childhood of parenting of the children be reviewed in making determinations as to the parenting plan. Pre-litigation division of labor should be reviewed, and not just who most conveniently controls the parenting. Young versus Hector, I'm not going to go through all the details.
You can skip the citation.
It is not appropriate to only review the last 4 to 5 months of parenting when looking at the best interests of the children. Before filing the petition, the child care was not a 50-50 time sharing by any stretch of the imagination.
The court must review the factors in Florida Statute 61.13001 in making its determination as to relocation, both temporary and permanent. Those factors and the facts in this case as to how they impact the children are as below. Number one, quote, the nature, quality, extent of involvement, and duration of the child's relationship with the parent choosing to relocate with the child and with the non-relocating parent, other persons, siblings, half-siblings, and other significant persons in the child's life, unquote. In bold. The wife has extended family and friends in the South Florida area, and the husband has have no.
Hey, Judy, sorry to interrupt. You're muffling a little bit. I can't hear you. Can you hear me? Maybe if you're listening and you can hear me, you might want to comment to Judy to let her know. It looks like she might be frozen. I'm going to go ahead and keep reading in the event that you can hear me at least. I hope you can. Whoop. I'm still here. Okay. So number one, the nature, quality, and extent of involvement and duration of the child's relationship with the parent or other person proposing to relocate with the child and with the non-relocating parent, other persons, siblings, half-siblings, and other significant persons in the child's life. The wife has an extended family and friends in the South Florida area, and the husband has no family in the Tallahassee area. The minor children have no other siblings. The children are close to both parents. I'll keep going. Number two, the age and developmental stage of the child, the needs of the child, and the likely impact on the relocation will have on the child's physical, educational, and emotional development, taking into consideration any special needs of the child. The relocation will not impact the children too greatly as they are not yet school age. They will be allowed to emotionally develop and will have more support from extended family relationships.
Oh, I'm sorry.
It's okay.
Can you hear me?
I can hear you now. I went through 1 and 2 while you were gone, so.
Okay. Am I showing up? I guess I'm showing up now because I had to get on my cell phone.
Yeah. It was like you were kind of muffled,
Good
and then
Lord.
eventually you were frozen. Yeah.
Okay. Yeah, because now I'm going through my cell phone. I can't believe it's actually working. So I'm going to have to pull it up on my cell phone now since my whole computer screen has frozen. So can you go ahead and keep reading?
Yeah, I'll
Thank
keep
God
reading.
you're here.
Yeah, right. It's okay. Okay, number 3. It's a little weird because there's the quote and then there's the answer, and you can't really see that unless you're looking at it, but I'll do the best I can. So number 3, and this is in quotes, the feasibility of preserving the relationship between the non-relocating parent or other person and the child through substitute arrangements that take into consideration the logistics of contact, access, and time sharing, as well as the financial circumstances of the parties, whether those factors are sufficient to foster a continuing, meaningful relationship between the child and the non-relocating parent or other person, and the likelihood of compliance with the substitute arrangements by the relocating parent or the other person once he or she is out of the jurisdiction of the court, end quote. In her answer, the wife will comply with all substitute arrangements, and the parenting time for the husband should be as extensive as his employment will allow. Number 4, in quote, the child's preference, taking into consideration the age and maturity of the child, end quote. The children are too young to voice any preference. Number 5, quote, whether the relocation will enhance the general quality of life for both the parent or other person seeking the relocation and the child, including but not limited to financial or emotional benefits or educational opportunities, end quote. The quality of life for both the wife and the children will improve greatly, as the wife will have a better, more consistent job with the help of extended family, and the children will have extended family as well. I'm on number 6. Number 6, in quote, the reasons each parent or other person is seeking or opposing the relocation, end quote. The wife is seeking to relocate for a better, more stable job and to have the children grow up in a stable and consistent environment and not relocate all across the country as the husband moves for ever better positions. Number 7, quote, the current employment and economic circumstances of each parent or other person and whether the proposed relocation is necessary to improve the economic circumstance of the parent or other person seeking relocation of the child, end quote. The wife's employment is going to be considerably better with this move. The husband has no intention of staying in Tallahassee and plan eventually to move to a much larger city and more prestigious school. The husband has considered Miami, New York, Washington, D.C., Houston, and St. Louis among his choices. How you doing there?
Oh gosh, I'm so glad you're here because I just basically had to restart my computer and it's starting up very, very slowly. So I'm sorry. Are you okay continuing to read?
Yeah, let me take a quick. I'm like you. My voice goes, but I'm good. I prepared.
Okay.
Number 8, in quotes, that the relocation is sought in good faith and the extent to which you're welcome. And the extent to which the objecting parent has fulfilled his or her financial obligations to the parent or other person seeking relocation, including child support, spousal support, and marital property and marital debt obligations, end quote. The wife is seeking this relocation in good faith. And number 9, quote, the career and other opportunities available to the objecting parent or other person if the relocation occurs, end quote. The career opportunities for the husband are the same regardless of the wife's relocation and will probably create a situation where the transportation is even better for the husband when he moves to a larger metropolitan area. And number 10, quote, a history of substance abuse or domestic violence as defined in all these statutes, which meets the criteria of other statutes by either parent, including a consideration of the severity of such conduct and the failure or success of any attempts at rehabilitation, end quote. This is not applicable. A review of some recent cases regarding relocation and not the ones submitted by the husband indicates that the judicial decision to allow relocation will be upheld unless it's an abuse of discretion. Norris v. Heckerman, when reviewing the cases and the law in this regard, it is important to note that there is no presumption for or against relocation when it will impact parenting scheduling. In this case, there's no parenting schedule, and the wife submits that a perfectly adequate one could be maintained, allowing the husband to fully parent and participate in the children's life while allowing them to be part of a bigger Jewish community, their larger extended family, a better financial situation for the wife, and a more secure and friendly work environment for the wife. All of these factors point to the relocation being in the best interest of the children. The burden is on the wife to show so that it is in their best interest. And once she has done so, then the burden turns to the husband to prove otherwise. The husband indicates that it is not the wife's best interest, but the children's that is at stake. This is true, however, the review of case law shows that facts very similar to those in this case have been held to be in the children's best interest. See Miller versus Miller, which reverses a denial of relocation, stating, as the child was only 3 years old, he had little in way of meaningful school, community, or friendship ties. The mother had been the primary caretaker since birth, and the mother has a significantly better job offer in Atlanta, Georgia than she had in Key West, Florida. Orta v. Suarez overturned a denial of a relocation request from Coral Gables to California, indicating that the mother had met her burden of proof based on the following facts. She could obtain significantly better employment in California. She had been the primary caretaker of the minor child. The husband's work schedule was more flexible, allowing him the ability to travel more for visitation than the wife. The reliance on the husband's promises to move to California had put the wife in an untenable situation, and the child was only 2 and would not be uprooted from any community. These facts are virtually identical to those in this case at bar, except that the wife in this case also has immediate family in South Florida. She is not asking to move nearly as far, and the husband actually intends to move at some point anyway. Finally, Rate v. Rate affirms a relocation request during the initial dissolution of marriage from Florida to the United Kingdom. The child in that case was 6 years old, and the wife actually moved during the pendency of the divorce without the court's or the husband's permission. Nevertheless, the appellate court upheld the relocation because the child would be close to an extended family in England. The wife had a better job in England. She was from the United Kingdom, and she now had a significant other. These facts are not as persuasive as those in the case at bar. When considering the factor of the statute along with the case law and the facts in this case, it's evident that a move to South Florida with the minor children is in the best interest of the children, and adequately secondary parenting can be provided by the husband so that he is able to maintain a meaningful relationship with the children. Are you there? Can you hear me okay?
Oh, yeah. Sorry. Okay. It's finally working on my computer, so I can take over. I'm so sorry.
No, you're okay. So you
what
know
page
where I
are
am.
You
right?
on?
Okay. So it looks like you'll top of 8. Wherefore the wife, Wendi.
Okay.
Oh, actually, it's the end. Let me finish.
Okay. Sure. I'll go ahead and read that as well as the.
Okay.
Okay. Go ahead.
Wherefore, the wife, Wendi Adelson, respectfully requests that this court allow her to request to relocate to Coral Springs with the minor children and establish a parenting schedule, allowing each parent appropriate time sharing and the sharing of the expense and time involved with travel. I hereby state certified that a true and correct copy of the foregoing has been furnished by electronic mail on this 13th day of June 2013 to Thomas L. Duggar, attorney for husband, at email address, blah, blah, blah. And it's signed by Kristen Adamson. The end.
Okay, great. Okay, can you hear me?
Yes, I can.
Oh, thank God. Okay, hey, sorry, guys. This is just growing pains and computer problems. Maybe I need a new computer. The whole thing was just freezing up and I had to switch to my cell phone, but I couldn't toggle to see the document by using my
it's hard to do it on the
Oh my gosh. Thank you, Dawn. I'm so sorry that's had to happen the first time that you tried to do this.
That's all right. It's all right. I use StreamYard a lot and it happens once in a while. Usually it's pretty good, but sometimes that happens.
Okay, so do you want me to just go ahead and read the next couple of pages so you can rest your voice and get something to eat or drink?
I'm just going to sip on my tea a little. As you can tell, I kind of have the same situation when I talk too much.
Okay, sure. Okay, thank you guys all for being out there and being patient with us, since this is not a real professional production. This is just YouTube. Okay, so please be nice to us. Okay, so this next is, of course, Dan Markel had to file a reply to that, and he was allowed to. So the very next day, June 14th, 2013, at 2:20 p.m., this was electronically filed by Dan's attorney. It says, husband's reply to wife's memorandum of law in support of her petition to relocate to Coral Springs, Florida with the minor children. Comes now the respondent husband, Daniel Markel, by and through his undersigned attorney, and files this reply in support of his motion to dismiss and in response to the wife's memorandum of law in support of her petition to relocate to Coral Springs, Florida with the minor children. This reply is to focus and distill the legal framework that governs the relocation petition filed by the wife. A, the standards for motion to dismiss in Florida. Under the Florida Family Law Rules of Procedure, the Florida Rules of Civil Procedure apply to this motion. See Family Rule 12.110. Under the General Rules of Pleading and Florida Rule of Civil Procedure 1.110, a litigant in Florida must engage in fact pleading, not notice pleading. Unlike the pleading requirements in the federal courts where notice pleading is the prevailing standard, the Florida Rules of Civil Procedure require fact pleading. Ranger Construction versus Martin Companies, 881 Southern 2nd 677 680, a 2004 case. What this means is that in order to state a cause of action, a petition must allege, quote, sufficient ultimate facts to show that the pleader is entitled to relief, unquote. MEBA Med and Benefits Plan versus Lago, 867 Southern 2nd 1184, 2004 case. Quote, at the outset of a suit, litigants must state their pleadings with sufficient particularity for a defense to be prepared, unquote. Horowitz versus Lask. And I'll just skip over all these citations here. Whether a pleading is sufficient to state a cause of action is an issue of law, citing Atkins versus Top Telecom. Wife's petition is facially defective for two reasons. First, even if all the facts in the petition were taken as true, it still fails to allege adequate facts to state a cause of action. That's because, as explained in husband's memorandum of law and motion to dismiss, the wife nowhere in the petition pleads that there is some economic necessity or that there is a parent who is or has been unwilling or unable to play a vital role in the raising of the minor children. Second, under the fact pleading standards of this state, wife's petition fails to state her case, quote, with sufficient particularity for a defense to be prepared, unquote. Horowitz Supra. We take these points up in turn. B, relocation is only allowed under specific and stringent criteria, which are neither present nor alleged by wife. Since husband has filed a motion to dismiss the petition to relocate based on his memorandum of law, the key issues are what's been pled and what the legal framework is. In reviewing a motion to dismiss, the facts that are pled must be construed in the petitioner's favor. Even under that forgiving standard, however, wife's pleading is manifestly insufficient in light of the legal framework governing the operative relocation statute. That statute, Florida Statute 61.13001, has been made clear in the 46 cases that have cited or interpreted that statute since it was enacted. Footnote 1. Okay, footnote 1 says, contrary to wife's memorandum at 3, around 18 cases or so actually provide relevant guidance for this court, and husband's memorandum of law addressed the vast majority of them. While each decision is specific to the situation, there is an obvious pattern that characterizes the outcomes, and that was the point of husband's memorandum of law, to show that there is a definite contour as to what counts as an abuse of discretion by trial judges on matters of relocation. So as a side note, I can just envision Dan Markel spending the whole night doing all this legal research and rapidly typing up a reply so that he could have his attorney file it within the next day.
Right. That was really quick.
Yeah. So getting back up to the part of his brief, it says, interpreting that statute, the Florida courts follow an abundantly clear pattern that was identified in the husband's memorandum of law in bold. Specifically, relocation in the state has never been authorized under this governing statute where there has been no economic necessity and where both parents are and have been substantially involved and are equally capable and loving. Okay, then he stops the bold print. Put differently, anytime a judge has permitted relocation, and it has been allowed on a very small number of cases, that decision has only been upheld because of some showing either of economic necessity, parentheses, created through no fault of the relocating parent, end parents, or because of some showing of a manifestly unequal relationship between the parents vis-a-vis the children, parentheses, or both, end parents. Husband's memorandum of law identified 13 cases where relocations were either denied, parentheses, and then those denials were upheld on appeal, end parents, or granted, parentheses, and then reversed as an abuse of discretion, end parents, because the facts didn't satisfy the criteria just discussed. Okay, are you able to read?
Contrary to the wife's memorandum at 3, which states that the husband's memorandum omitted any discussion of cases where relocation had been permitted, husband's memorandum of law also identified very few, in parentheses 4, cases in which relocation had been permitted, in parentheses, and upheld, or denied, in parentheses, and then reversed and remanded for reconsideration. See husband's memorandum at 4 through 5, discussing, in parentheses, discussing and distinguishing Norris v. Heckerman, Miller v. Miller, Orta v. Suarez, and Valquite versus Rodriguez. By contrast, wife's initial petition did not cite a single case in support of its petition. Now, in desperation, and only a few days before the hearing, wife's memorandum of law musters citation to fewer than a handful of cases, all but one of which were addressed in husband's earlier briefing. Specifically, wife, in parentheses at page 6 and 7 of her memorandum, cites and discusses the following 4 cases: Norris, Miller, Orta, and Wright versus Wright, or Rate versus Rate. To elaborate briefly, Norris versus Heckerman provides no support for wife's case, as the relocation was permitted there in a context where the husband had been away from the children, living in a different state, and only later on moved to where the children were and began, in quote, exercising weekly visitation, end quote. By contrast, Mr. Markel, the husband here, has been intimately involved with every facet of the children's life from day one and continues to be a daily presence in their lives. Ms. Adelson, the wife here, stipulates the husband has a great love for the children, that the children are very close to both parents, and that the parents had been time sharing on equal basis from the beginning of the separation more than 9 months ago. She also, as developed below in section C, offers no specific allegations about how she was in fact the primary, in quotes, parent prior to the separation. It's a bland assertion that fails the standards of fact pleading. Miller v. Miller, likewise, is of no support for the wife. In Miller, the mother had no economic prospects in her city, whereas she was offered a job in the new city and she was getting remarried. Moreover, and importantly, the husband in Miller was working 2 jobs and was deemed to be either unavailable or unwilling to attend to the child adequately. Furthermore, the mother was the primary caregiver for 5 nights a week and was home with the child since birth. Finally, the court didn't even reverse and order the relocation. Rather, it just remanded the case for further consideration. By contrast, Ms. Adelson does not deny that she is employed as clinical professor of law at Florida State, although she was in a visiting position prior to the fall of 2012. In December 2012, she was promoted to be the director of a legal clinic that the law school faculty unanimously approved, and she was hired after a national search was performed. Moreover, except for 3 months of maternity leave that she took after the birth of each child, she has worked full-time at the university. She has a stable 6-figure job waiting for her at FSU. Accordingly, there is no economic necessity. Moreover, husband is not working 2 jobs, but just one. As a full tenured professor, he also has plenty of time and inclination to spend with the children here in Tallahassee. And there's no I'll just finish this paragraph. And there's no dispute that he is involved in an involved and loving father who is keen to be a daily presence in the lives of his children.
Third, Orta versus Suarez, 2011 case, again is mischaracterized by wife. The wife in that case was a foreign national and foreign-trained dentist who could not be certified anywhere in the United States besides California. Furthermore, her husband had been dishonest with her in numerous ways that left the wife and child destitute, and had made promises to her that she had relied upon to her detriment. But the key point is that the wife in that case had an economic necessity created through no fault of her own. That part is italicized. By contrast, Ms. Adelson's stated hope is to make scarcely a few dollars more in her new position compared to what she is able to earn here in Tallahassee, in a position that is stable and yet flexible. Moreover, unlike the husband in the Orta case, there is no allegation that Mr. Markel has sought to deny Ms. Adelson any appropriate child support. Finally, wife refers to rate versus rate, 2011. The key fact omitted from wife's discussion is that Ms. Rate had no visa to work in the United States, and so relocation to her home country was an economic necessity. See 71 Southern 3rd at 140. As with Miller versus Miller Supra and an Orta Supra, rate doesn't involve merely a better job for the wife. Rather, no plausible work opportunities were available for these wives where they were. Again, and by contrast, Ms. Adelson is employed as a legal educator in what is, by any measure, a wonderful job with a public university during a period of great economic uncertainty for those in private practice. And as such, it is one with job security, a panoply of benefits, and fantastic flexibility that, according to her own admissions, redounds to the benefit of the children. Needless to say, this is a position that she deserves on her own merits and has earned on her own merits by dint of her hard work for the university and the College of Law over the years. To summarize this point, wife's memorandum of law not only fails to address the 13 cases that all denied relocation, but wife's petition relies on the cases that husband already discussed and distinguished. Wife's petition is facially defective under Florida law because it fails to allege any basis for economic necessity. Wife doesn't claim that she can't make ends meet in a low-cost city on 6 figures, nor does she claim that she couldn't find higher-paying work in Tallahassee in a private law firm. She doesn't allege any necessity, especially one that is created through no fault of her own. Second, wife never alleges the existence of a father who is or has been unable or unwilling to be deeply and lovingly involved in the lives of the children. Wife's memorandum concedes that husband has great love for the children, that children are close to him, and that he has been vigilant about protecting his parental rights so that he can be as involved in the children's lives as possible. In short, there is no legal basis for this petition to continue. It should be dismissed with prejudice and costs awarded.
C, there is inadequate specificity to prepare a defense. Wife's petition is defective because it fails to justify the standards necessary for fact pleading in Florida courts. It makes grand and sweeping claims without offering specificity adequate to prepare a defense. Here are just a few examples. 1. On page 2 of her memorandum, wife, quote, submits that she has been the primary parent of the boys up until the date of filing the petition for dissolution, end quote. She bolsters this pituitively by reference to the fact that the husband has traveled for work, but she doesn't identify how much he has traveled for work, how much she has traveled for work or for fun, in parentheses, and that has been extensive, as will be shown at the hearing, close parentheses, or what standards she thinks are relevant to determining who is a primary parent. Number 2, on page 2, wife writes that husband is, quote, having so much difficulty, end quote, with wife's decision to leave the marriage that he, quote, told several of her colleagues and friends that she must have mental health issues, end quote, and that she, quote, has stolen money from him, end quote. She doesn't identify who these people are or when these allegations were made or whether she denies these allegations. Number 3, on page 3, she describes her position as, quote, tenuous, end quote, and that husband has made it, quote, difficult for the wife with her colleagues due to his statements and actions, end quote. But she does not identify any way in which her position is, quote, tenuous, end quote, other than the fact that she is not a tenured professor. One can be in a stable, flexible, and wonderful position without enjoying academic tenure. The other persons who have the same position as her have been there since 1991, 1995, and 2001. There doesn't seem to be anything tenuous about being a clinical professor at a public university. Moreover, wife does not identify a single instance in terms of where or how things were difficult for her in her employment. No adequate defense can be prepared against such a vague and unsupported assertion. She has been working continuously in her position. She is slated to teach this fall at the College of Law, and since she works in a separate building, she has only seen the husband at the workplace on 2 or 3 occasions since October. In short, wife asserts that husband has made it difficult for the wife to work with her colleagues, but offers no allegations or specific instances of ways in which it was difficult. Which is difficult. And there is a footnote. The footnote reads, moreover, the evidence will show that, in fact, the College of Law has publicly showered accolades and publicity upon Ms. Adelson, both before and subsequent to her promotion to clinical professor. Back to the page. In short, she has a contract with a public university which can only fire for just cause under the relevant collective bargaining agreements. By contrast, there is no evidence of even a contract with a private law firm, just a 2-line email confirmation of an offer of employment as an at-will employee with no mention of benefits, flexibility, or stability.
Moreover, any claims of difficulty in the workplace are utterly belied by the fact that after the separation, the faculty unanimously decided to make wife's legal clinic permanent, and her being hired to direct that clinic was the unanimous decision of the ad hoc committee that conducted a national search. In short, wife asserts that her position at FSU is tenuous, but doesn't explain why an at-will employee relationship with a private law firm would be less tenuous than a state employee position with a university and a collective bargaining agreement. Number 4. On page 4, wife writes that no arrangement exists currently regarding parenting. She does not even allege that she has ever offered a, quote, set time sharing, unquote, arrangement to which husband has refused. Wife doesn't allege any specific instance or evidence of intransigence other than that husband wants a 50-50 arrangement. She doesn't allege any specific instance in which husband wouldn't offer extra hours. Moreover, she doesn't offer any allegation of her own willingness to offer extra hours without makeup time. Footnote 4. Okay, so the footnote says, as the evidence will show, husband has frequently sought to facilitate long-term planning, and wife has been the one to accept parenting agreements and then repudiate the fact of her agreement, and instead desire to renegotiate and extract more time with the children. The evidence will also show that wife has been out of town more than the husband for work and for pleasure travel, a choice that the husband has been happy to accommodate. As husband has told wife in person and in numerous emails, he will always be happy to work around her reasonable preferences. Okay, let's get back up there. Number 5. On page 5, wife asserts that she will have a, quote, better, more consistent job, unquote. But she doesn't explain what's better or what makes it, quote, more consistent, unquote, or, quote, more stable. unquote, than being a clinical professor in a clinic that has been made a permanent part of the College of Law. Nor does she explain how working as a law firm associate is preferable from the standpoint of the children regarding how much time she will get to spend with them. Number 6, the wife states on page 5 to 6 that husband, quote, has no intention of staying in Tallahassee, unquote. But she doesn't say when he said that, to whom, and with what qualifications, if any. She references jobs or cities he has considered, but she does not mention that all of those were prior to having children, let alone prior to the separation. D. Various errors pervade wife's memorandum. Although pleadings are to be read with charity, there is a need for specificity and plausibility under the Florida civil pleading standards. The wife's pleading reveals a parade of obviously false statements of fact that cumulatively demonstrate that the petition warrants little deference. Number 1, contrary to the wife's memorandum, at 1, the couple never lived as a married couple in Washington, D.C. They lived there for less than 3 months while they were engaged in summer of 2005 before they moved to Tallahassee, where they have lived since 2005, except for the academic year of 2006 to 07.
Number 2, wife's, quote, entire immediate family, end quote, does not live in the South Florida area, contrary to her memorandum at 1. Her parents and an older brother, in parentheses, who is an unmarried and hardworking periodontist without children, and parentheses, live there. Her oldest brother, who is married and has 2 children, lives in upstate New York. She has no first cousins or uncles or aunts in South Florida. Number 3, while neither party has extended family in Tallahassee, the parties have lived in Tallahassee for all but 1 year since 2005. And more importantly, the children have lived here their entire lives. Ben is turning 4 next month and Lincoln is almost 3. The parties and the children have over 50 families with whom they have celebrated milestone or done play dates with, and they are doing fine in their current environment even after the separation. Number 4, wife writes that she filed her petition in August 2012. This is false. It was on September 10th, 2012, the date that she told husband for the first time that she wanted a divorce, and the date that he came home to a house with no wife and no children. The whole separation and filing for divorce was a complete surprise to husband and to his friends, family, and colleagues. Number 5, wife writes that wife was a visiting professor, quote, until 2 months ago, end quote. But in fact, the dean of the College of Law announced Wendy's appointment to a permanent position in December of 2012. That was 6 months ago. E, conclusion. In sum, while pleadings must normally be read with charity to the petitioner, it does not mean suspension of all disbelief, especially in a fact pleading jurisdiction like Florida. Pleadings must be specific and offer some form of plausibility. The wife's pleadings are vague, filled with rank and obvious falsehoods, and the legal analysis is fundamentally inept. Even if all the facts in the wife's petition were taken as true, there is no allegation of economic necessity or parents who are unwilling or unable to be involved in a deep and loving fashion. For the preceding reasons, the petition should be dismissed with prejudice and costs be awarded to the husband. Indeed, if costs are not awarded, then wife and her affluent parents who are bankrolling wife's litigation so they can enjoy closer access to the grandchildren will persist in vexations and groundless litigation, and thereby prevent the parents from reaching a space where they can cooperate, collaborate, and communicate effectively and warmly in the project of raising their wonderful children.
Okay, so this is pretty much the end of his brief. I hereby certify that a true and correct copy of the foregoing husband's reply looks like there might have been something missing, because usually There's like a little ending there. But anyway, this just flat out says that a copy was sent to the other attorney. Yeah, so I feel like there's a page missing, but that's no big deal. So that's the meat of his reply. So are you ready to move on to the order?
Yes.
Okay, so I'll take that off the screen. We're almost done. It's a very short order because the judge quickly realized that Wendy's motion was frivolous. So let's see. Bring it up there. Thanks again so much, Dawn. Sorry about the problem with my,
You're
computer.
fine.
Okay, here is Judge Barbara Hobbs's order, which was filed on June 24th, 2013. Or actually, yeah, this says it was filed on
June 13th.
June 21st, 2013. Okay, that's interesting. But then it was recorded later in the clerk's office. Okay. Do you want to read this one?
Sure.
Okay.
In regards the marriage of Wendi Adelson, petitioner wife, and Dan Markel, respondent husband, or this is the order on wife's petition to relocate with minor children. This cause having come before the court on the petition of the wife to relocate with the minor children to South Florida, and the court having heard argument of counsel and testimony presented by the wife, and the wife having rested her case, does order and adjudge as follows. 1. This court does not find that wife has met her burden of proof that a relocation is in the best interest of the minor children. Number 2, as such, the parties stipulate to the denial with prejudice of the wife's petition to request to relocate with the minor children. Number 3, the court orders the parties to mediation to resolve the remaining issues pending final hearing in this case, currently set for July 31st and August 1st, 2013.
Number 4, the parties have agreed to the following temporary parenting schedule without precedential value for the time up to the final hearing. A, the month of June 2013 has been resolved. B, the husband shall have from the end of June until July 4th at 9:30 a.m. C, the wife shall have July 4th at 9:30 a.m. until July 15th at 9:30 a.m. D, the husband shall have July 15th at 9:30 a.m. until July 22nd at 9:30 a.m. E, the wife shall have July 22nd at 9:30 a.m. until July 29th at 9:30 a.m. F, the husband shall have July 29th a.m. until August 2nd at 9:30 a.m. G, the wife shall have August 2nd at 9:30 a.m. until either the evening of August 6th or the morning of August 7th, depending on the flight schedule for the husband as per below. H, the husband shall be allowed to take the children to Canada from August 7th until August 21st, 2013, and the wife shall sign all necessary paperwork to do so. I, the parties agree to make a good faith effort for a daily phone call for the children, and the parent out of residency and the parent in residency shall facilitate that call. And J, the parties shall make a good faith effort for a Skype every 4 days between 6 and 8 p.m. for the parent out of residency, and the parent with the minor children shall place the Skype, done and ordered in chambers in Tallahassee, Leon County, Florida, on this 20th day of June, 2013. Barbara K. Hobbs, Circuit Court Judge. Okay, so that's it. I just want to note also that this is interesting here where it says the parties stipulate to the denial with prejudice of the wife's petition. So with prejudice means that you agree you're not going to bring up this issue again. So in a way, that was kind of strange that Wendi or her attorney would agree to that. I mean, if it was such a big deal to Wendi and Donna, then why would they agree that this is going to be done with prejudice, which means that you can't bring up the same issue again? So that's very interesting because later, I guess, the more they thought about it, the more they thought, well, maybe we shouldn't have agreed to the denial with prejudice because maybe we want to be able to bring it up later, but oh well, you know. So what are your takeaway feelings on this? What are your thoughts, Dawn? Are you there? You're muted. You're muted.
I was muted while I was not reading. Sorry. Yeah. So first of all, it's kind of chilling, to go through these, knowing how it ended. But I have a question for you, since this is your specialty, family law. It's in my understanding, it's pretty typical that a judge would want to keep the father involved as long as he was willing and able to be involved, right? So this isn't like she made some kind of off the wall ruling here. This was pretty much a natural outcome given the court's desire to keep families together, right?
Yeah. Well, I definitely found Dan's, or his attorney. I'm sure Dan really wrote a lot of that stuff since he's a law professor. But boy, can you just visualize Dan freaking out and just staying up all night doing all the legal research using Westlaw or Lexis or whatever legal search software he had, just like banging out the best legal brief he could so that he could make sure those kids were not taken away from him.
Right.
And it's so sad, sad. Reading through it and thinking he was so passionate that he wanted to be a part of his kids' lives. And look what happened to him.
Yeah, it really is. It's really chilling. And I mean, children should be so lucky to have a father that would want to be involved. This is not, I mean, and she did. And once I read through it, it's like, yeah, she didn't really provide any real support of why they should be taken to Miami. I mean, so her parents lived there and her brother. That's it. Right.
And
maybe
it was all about them and their wants, and who cares about Dan, even though he's the father of the children. It was very dismissive. And I granted, I am not licensed in Florida, but based on practicing law in Virginia for a little while, as well as North Carolina for so many years, everybody, or most people, know that if you want to move away, then you can move away. But, the other parents still should be able to have the kids then if you want to move away for no good reason.
Right.
So, yeah. And so obviously Dan found an overwhelming number of cases that supported his position. And, the judge ruled pretty quickly, I think, in just denying that petition to relocate and saying, okay, that's it. Go away. So
I liked how he had the little flourish of taking the cases that she had quoted too and using those against her in some of those cases too. So I mean, maybe in the end Wendi knew, maybe she agreed with prejudice because she knows the law too. She probably knew full well that they did everything they could at that point to try this and it wasn't going to happen.
Yeah. But who knows? Maybe I'm just guessing, but maybe Donna had no idea what that meant when you say that you're going to voluntarily agree to dismiss it with prejudice. That means that's it. You're going to be stuck driving back and forth from the Miami area up to Tallahassee anytime you want to see your grandkids or pay for a flight or whatever. So, yeah. It's just so ridiculous that, they allegedly thought that is a good idea. Just kill off the dad then. Just kill him. I mean, it's just like when Charlie said it so glibly in that Dolce Vita recording to Katie. Yeah, just kill him, kill that undercover cop. I mean, is that the solution to everything you want? Just use your money and kill off people that stand in your way. It's so bizarre.
Yeah. And I also think about how, they were considered, I don't think they're considered this anymore, to be a prestigious family with a lot of power and ties to the courts and politicians, but they just thought they were going to get their way and couldn't handle that. I don't know. I mean, it's as to motive, I guess they don't have to prove motive, right, in the trial. So I have an unrelated question. Sure. After watching the whole the new Harvey and Charles Adelson, the
Matsuri
video, So this camera and recording device was in a bag.
Yeah,
I kept feeling like I was in a salt or pepper shaker looking out with these little holes.
Yeah, it is kind of gross. Was it called like tryptophobia or some sort of phobia when you hate seeing those things with like holes and netting?
It was. And then on one of the on part of it, I kept seeing, like, you know how when you look at the clouds and you see different things in the clouds, and it's like, oh, I see the giraffe or whatever. I saw two different beings in the upper left corner of each one of those. I was just staring at. One was like a leprechaun, an evil one though, and then I forgot what the other one was, but just staring at that for so long.
And then trying leprechaun was not Charlie Adelson. That was weird, seeing his face through the holes. Yeah.
And that it was kind of weird when he looked right at, when he realized he was being recorded. That was just, it was really, yeah, it was really icky. His big brown eye. Anyway.
Yeah, I do wonder what that undercover agent looked like. Was it a man or a woman? You know, like, were they just dressed casually to kind of blend in? But who knows? But at least they were able to record what they got.
They were. How did he know, though? I mean, how did he know it was in there?
That's what I'm not sure. Maybe he saw like the lens, like bulging through the bag or something.
I watched it twice. I think toward the beginning, I did see like some red light. So maybe a red light went off.
Yeah, maybe light flashing.
Yeah.
Who knows what that equipment looks like, because I sure don't know. I'm just guessing it was probably some sort of black bag that was resting on a table.
Yeah.
Because it was high enough to get his face.
Yeah, it was almost like it was on their table in a way, but he must have been sitting across from them.
Yeah. I mean, that would probably make me suspicious too, because usually people don't put a bag right on the table where they're going to be eating. They would put it on the chair. Yeah. So maybe the placement just kind of wasn't the right place, but at least it recorded them and you could hear most of what they were saying or some of what they said. Yeah. So let's take a look here. Hey, everybody. The regular crew is here. Thank you, True Lifestyles. Angela, always being here. Oh, you're a great expert to share. Oh, yeah. Thank you. Yeah. I mean, it definitely was kind of like an uphill battle for Wendi and her attorney to make those kinds of arguments. You know, I'm sure her attorney already told her and Donna up front that this is not likely to win, but if you want to pay me $600 an hour, I will argue it for you.
Sure.
Yeah. Let's see. Okay, so they're thinking, were they at a sushi bar? Well, probably not, because didn't it seem like Charlie was facing his father as opposed to them sitting side? Well, you can't really tell, though.
It looked like they were sitting next to one another.
Oh, really?
It looked like, to me, it looked like Harvey was closer to the device and Charlie was next to him because he kept looking over. Yeah.
Oh, okay. Interesting. Well, you're very observant. Yeah.
I guess so. Yeah.
Yeah. Exactly. If you're innocent, why would you be paranoid of being recorded?
And they did say, we're going to talk outside now. After he whispered,
Mm-hmm. That's right. Oh, okay. So Maui agrees it was a sushi bar. Okay. Thank you. Asian Posh said Dan just wanted to be a dad. He got murdered for it. Yeah, and that's what's so sad when you read these briefs. It's like, wow, you know, you can tell that Dan really put his heart into it. He had done all this excessive research and drafted it up to look like a law review article, you know, because he wasn't going to let Donna and Wendi just take those kids and run away. And then he's going to fly back and forth or drive back and forth once in a while to see the kids.
Yeah, and I have to believe, and it wasn't just that like the inconvenience and the impracticality of it all, but he really was concerned about their future. And I imagine the influence that this family might have on his children.
Mm-hmm. Yeah, exactly, because he was already starting to get a taste of it, you know, the way the family behaved and how they treated Wendi versus,
sad.
Maybe. Let's see. Okay, so Clarissa, thanks for being here. Well, he made it obvious he had something to hide when he said, I think there's a recorder or a waste camera, to his father. Then he said, let's go outside. Yeah. Charlie was talking about the food. Okay. Or was it in that bag? Okay. Yeah, it was definitely a Japanese/sushi restaurant. Okay. Yeah, they talked about whether it was legal, and Charlie said not without a warrant. Yeah, I recall seeing that as part of the captions too. But I didn't really have the patience to listen to that full video that Mentor Lawyer graciously put up on his channel. Did you listen to that whole video?
I think after a while, I was just, I mean, I probably did. I had some other stuff going on. I can't just sit and watch those. That's why I love that you're doing this reading, and I'm happy to do this with you, because usually I can just listen, because I can't just sit and read. And I don't have the patience for it.
Yeah, exactly. Yeah, sometimes people like to hear things while they're driving or doing other stuff around the house. People have told me they're cleaning their house while listening. So thank you everybody out there. Whatever we can do to make things easier so that information is put out there. Yeah. It was like looking at Charlie through the eye of a bug. Yeah, it's not a June bug. Yeah.
Oh.
Okay. Let's see. Hello, True. Thank you so much, True Lifestyles. Everybody check out her channel. I'm sure you guys are all subscribed to True Lifestyles also. They're their own organized crime family. Unhappy, take them out. Yeah. Nowadays, can't they just bug your phone? Yes, they can, but it's great that they also sent the undercover agents to go out and do more, because they weren't going to just keep talking about everything over the phone. Yeah. Judy, do you think the Adelsons had anyone killed before Dan? They act so nonchalant about his undoing. It makes me think so. Well, I haven't heard of any such allegations. Have you, Dawn?
No.
Yeah, I haven't heard of any allegations other than, that thing that Fancy Fiction posted about Charlie allegedly paying off some police officers to kick his former business partner out of the bagel store or the restaurant that they used to own, something like that.
Yeah, out of the property. I did have a question for you. Okay, I always forget what this is. So Donna and Wendi and Charlie, before he was arrested, were they named by Kappelman as person of interest, or were they named as something else?
They were actually named as co-conspirators. Well, Wendi, Donna, and Charlie.
Okay. It's interesting. Okay, so if they've been named as a co-conspirator already, then I'm guessing they didn't need a warrant, as Charlie was saying. He doesn't know the law anyway, but
no,
do they need a warrant?
Well, they definitely, the government definitely needs to get a warrant, and we're talking about different timelines, because the warrant where they tapped Charlie and Katie's cell phones was back in, I guess, early 2016, whereas the three people were not named as co-conspirators until I think maybe in a filing in January of this year. Yeah, but anytime as far as I know, anytime the government wants to tap your phones or get a warrant, you still have to get a warrant signed off by a judge in order to do that.
But you wouldn't necessarily know that they've done that.
Oh, of course, yeah. I mean, that would just kind of ruin the point,
Right,
you had to tell the person, hey, by the way, we want to tap your phone, or
so the way he said it, so the way he said it, it was like, well, they'd have to get a warrant. In other words, I would know about it.
Yeah, nah. I mean, he's just talking out of his orifice. Yeah,
he's just Charlie.
Okay. Armand Fence, thank you for being here. Dawn is absolutely right. There are so many deadbeat dads who will not even cross the road to meet their kids. Dan's kids have suffered a great loss. Yeah, so sad. Yeah, and we've only seen a few of the pictures of him, having fun with them, and I've heard that I think it was his mother. Yeah, Ruth Markel mentioned that his whole house was like preschool decor, where he would string up, put up a laundry line in the living room and hang up all the kids' artwork, and had all their stuff all, made up to look like it was a preschool in the house. So
it's really neat.
Very child focused. Yes. I agree. However, Wendi landed the bigger fish. Harvard Law means Dan was going places in his life. She dismissed him out of her threatened superiority complex. Oh, okay. So what did Patty say? Okay. I guess I'm going backwards, not chronologically. Sorry. Gee, what's going to go wrong when you marry someone you don't love or respect? I guess Wendi was impressed with Dan somehow, but later decided to dismiss. Yeah. I mean, she did say in her podcast something about how she didn't really love him, or she wasn't really attracted to him, but she felt that, the love dies out anyway in all marriages. So, he would be a good dad or something to that respect. Yeah. Okay. Let's see what other new comments. Yeah. I mean, it's really great that so many people care about this case and are participating. The only downside is that now I don't think I have time to flash up and respond to everybody's questions or comments, but we'll see. I believe Charlie was wrong about a warrant. Oh, yeah. Yeah. If you're in a public place, then there is no expectation of privacy. Yeah. Speaking of low-life dads, Charlie Adelson. Yeah.
Yeah.
Thank you so much for everything you do. All of you are amazing. I feel I am in such good company with my obsession with this case. Yes, welcome to the Dan Markel Adelson Case Addicts Forum. Yeah, but I feel like this is so important. And then we're also letting the greater community as well as the Markel family know that other people, even strangers, really are, caring about the case and want to make sure there is justice. Yeah. Let's see. Oh, am I keeping a detailed trial timeline? No, I haven't had time to create a timeline, but it seems like you have the artistic skill and people helping you to make those graphics for your channel. Yeah, so that's great. Thank you for posting the deposition timeline on my timeline. Oh, did I? Oh, okay. Well, thanks. What was the date of this hearing? Oh, okay. So the order, let's get back to it again. I think it was June 21st.
June 21st.
No, she signed it on June 20th. Yeah. Yeah. But I'll share it with you anyway, just so we can be 100% sure. Right. So from what I've read, Donna was there during that hearing. So I'm sure she was like absolutely livid and going bonkers right after leaving.
Oh, she was there for the final
yeah, I
order?
think so. Yeah, okay. for the hearing. Okay. So let's take a look here so we can be sure. Yeah, because sometimes it's not actually filed by the clerk's office until after the hearing. So that's why there's a discrepancy in the different dates that you see at the very top of the document versus when the judge. Yeah, so the judge signed it on June 20th, 2013.
The order.
Yeah. So that's the date of the order, but it wasn't filed in the clerk's office until the next day, June 21st, 2013. And then, of course, electronically recorded on June 24th. Okay. But I would say in general, the order was entered on June 20th, 2013. And as we heard from Lacasse, supposedly Charlie had already been looking into a hitman back in 2013, probably summer after this hearing. So, let's see. Sorry. Okay. Yeah, those boys should not be with the Adelsons. I'm an addict for sure. Thanks for all you do, what you do. Thank you for being here, everybody. Judy, did you hear Charlie's long story in the Matsuri video about June's audition for the Miami Dolphins cheerleading, bragging about her working at Hooters for 10 years? Yeah, that's what, no, unfortunately, I didn't have the time or the energy to keep listening because it's a really noisy, just like chaotic video. So you really have to be focused to try to listen, to try to get any sort of nugget of useful information. So I haven't had the time and patience to do that. But if that's what you heard, then thanks for telling us so we don't have to listen to it. Yeah. Because I did see on her social media, well, obviously I saw lots of pictures of her working at Hooters and in the Hooters girl uniform. And then Miami Dolphins, I could have sworn I already saw pictures of her in the Miami Dolphins uniform and, being with the other cheerleaders. So I don't know if that was part of the audition process or did she really make it or not, but whatever. I mean, that's just so goofy. Yeah. I mean, working at Hooters, what? I mean, my little sister worked at Hooters before and she only worked there for a couple of months because she said after the grand opening was over, then the customers dropped down and it really wasn't really worth the money. They didn't make as much money after a while. Yeah. But the Hooters girls, I guess they all have to kind of like flirt with the men and take down the hula hoop and, do the hula hooping and do stupid stuff to try to get big tips, right?
Yeah. He mixes with really great company, that intellectual set.
Yeah. Okay. Have you listened? Oh, yes, definitely. Asian Posh asks, have you listened to the Wandery podcast over my dead body called Tally? Yes. Yeah. I sure hope they update it. Yeah. I don't know what Matt Scherer, is that his last name? I don't know if he's still working on doing something else, but it became so popular.
Yeah. It's a great podcast.
Great podcast. Okay. Denise says, funny how Wendi changed a boy's last name from one of the most respected names in the legal world, Markel, to a name associated with contract killing and dysfunction. Yeah. Well, that all happened later, right? Yeah. Let's see. Love the Over My Dead Body podcast. Why do you think Katie never admitted to being the middleman in order to get a deal? Yeah, I think it was just overconfidence, right? Like thinking like, well, I'm never going to admit to it, and then I'm going to get off. So, and then probably get more money from Charlie's family.
I felt that way too. And possibly she felt threatened, or that her children or family would be either financially at a loss or just threatened in general if she did something like that. But I mostly felt she just really thought, especially because she had the mistrial, that she was going to, she seemed overly confident when she testified the second time around too.
Yeah. She's not very smart. So thinking like, oh, I'll just sit there and look stupid with my mouth open, like,
and get by with it. Yeah.
Remember,
Yeah, it was weird.
Yeah.
The funniest part in the closing argument of that second trial where Georgia Kappelman was talking about that, and she said, and she just, I don't know, like the way she imitated Katie. I thought I just about died when I was surprised she did that, but it was kind of classic. Yeah.
That's why Mentor Lawyer did a specific short video highlighting, Katie falling apart on the stand. Yeah. Is Rashbaum a good enough lawyer to get Charlie out of this? That I do not know, but it just kind of looks like he has had a lot more experience doing white collar crime cases as opposed to murder trials.
Yeah, I saw that too. I thought that was odd. But I'm impressed with him so far. I mean, he seems to comport himself very well. He's not going to be annoying, I think, which is nice because we're going to be watching and we don't want to be annoyed.
Yeah, that's true. I mean, at least he came across as professional and,
and he was very cooperative with the state. He wasn't being all snarky and weird. So yeah, I thought it was weird too, because as soon as I heard who he was, I looked at his resume and I thought, he's not a defense attorney except for white collar, unless they're going to bring in these other things about all these other things.
Oh no, because he's not on trial for insider trading or insurance fraud or anything. It's a murder case. So,
but I mean, as far as his character, I don't know. I didn't know why he would choose him.
Yeah. Who knows? Maybe a personal connection or whatever.
Maybe nobody else wanted to take him.
Yeah.
He might be ostracized. Yeah.
Yeah. Maybe the former attorney finally got fed up with him, was like, well, you're not listening to what I'm telling you to do, so I got enough money, so go away. Yeah. So Pam says, hi Judy in chat, when you married a whole family. So true. Date a long time and you will see what your future will look like. Crazy and controlling doesn't change. Run fast and far. I agree. Yes. Yeah. And that's what's kind of sad, is hearing that a rabbi actually told Dan at the wedding that he shouldn't have married Wendi after that whole fiasco with the food turning out not to be kosher. Yeah. So very, very sad. Hi, Seagate. How did you get in? Oh yeah, I should have asked you that. How'd you get in, or how'd you even hear about this case?
Gosh, that's a good question. It's been going on for a while. I don't know. I was thinking about that the other day too. Maybe through the podcast. I can't remember where I first heard about it, but I think I listened to the podcast, and then when the trial, I can't remember, honestly. Yeah, it's been a blur because so much has happened and it's been so many years.
Are you interested in other criminal cases or other lawsuits?
I am. It's kind of a new-ish thing for me the last couple of years. It used to be that I couldn't actually handle anything like that had anything to do with any violence, but I'm finding it more therapeutic now. And I think when you're watching YouTubes and any social medias, you're starting to get that algorithm and they're feeding you things. And so I've been following Mentor Lawyer for quite a while, since he had hardly any followers.
Yeah, cool.
And maybe it was that interrogation video of Wendi that he posted. Maybe that was it. And then I started looking at it. But yes, I'm interested. Gosh, I mean, I tried to start watching the Ohio, that massacre.
Oh yeah, the Rhoda and Wagner
marrying into a family, or getting involved. You're marrying a family. That was a little hard because I tried to watch it yesterday, but the judge evidently gave the witnesses the option to not be on camera and on audio. So the live stream was just like a blank page most of the day because the witnesses, and they're not even giving the transcripts. It's kind of like, why even have it live streamed if half of the witnesses aren't going to show up? But anyway, so let's see. And then the other one with Denise Williams.
Oh, really, yeah. I totally got into that. Yeah.
Let's see. There have been several. There have been several now, but sometimes I have to take a break. Some of them are so gruesome, I can't handle it. But I just really feel, and I love that, Judy, that you do that about every time you open up, you're so appreciative of other people that are interested in justice for the Markel family, because that's how I feel. It's just kind of tearing on my heartstrings, and I want Ruth to have access to her grandchildren, because now they've been deprived of her as well, and their grandfather and auntie and cousins too. Mm-hmm. So just I guess I have a strong sense of justice. I guess I don't know.
Yeah, I think that's what really pulls a lot of us into this case too, is seeing that like the poor Markel family, and it's not just Ruth and Phil Markel, but also Dan's sister Shelley and her children, and her husband and the cousins, and Dan had a big extended family in different countries, and he made so many friends, friends from the legal community, from Harvard, he also had a master's degree from, I think, University of Cambridge. So, so he lived all over the place. He worked in different places. He had friends of all different, backgrounds and nationalities, and just worked hard to build this network of a supportive group of friends and everything. And he wanted to be a good father. So we all kind of identify with that, like, wow, he wasn't just some plain old schmo, because a lot of times there's so many crimes, and some crimes don't really rivet you as much as other crimes. Yeah.
Seemed acutely unfair. I mean, unjust, and he just had so much to give to his family and the community abroad. I didn't realize I guess I forgot he wasn't an American citizen. I guess it doesn't matter that he's still being protected by law here. I forgot he was a Canadian.
Yeah, that's
right. He didn't have dual citizenship.
No, I think he mentioned in one of those filings something about how he was supposed to be like getting paperwork done for immigration purposes, but because Wendi left him, he had to do something else. I can't remember the details, but maybe he was on his way to trying to get a green card or whatever. I'm not sure. Okay, thank you, 5car5. The children have been in the company of a family of murderers for 8 years, and this is the best for them. Yeah, exactly. It's like, come on, like he's the father. He wanted to be in the kids' lives and stuff, and it wasn't like Wendi had no job and no economic opportunities in Tallahassee. I mean, she had a great job. Most people would love to be paid, $100,000+ a year to teach students at law school and get the summer off and all the perks of being a professor. So is $180,000 a fairly normal salary for a tenured law professor? Actually, yes, it is. Yeah, although it's still sort of high to me, just based on what I know, since my ex-husband is also a law professor at a different school, of course. But for Tallahassee, I'm pretty sure is considered a lower cost of living place. So $180,000 back in 2013 is probably worth, who knows, like being paid $250,000 now in today's dollars, roughly, or $230,000. I'm just guessing. So, so from what I heard, it sounded like the dean of FSU Law School really liked Dan and thought Dan was like this hotshot legal scholar, and he's going to leave if we don't offer him more money. So I think that was also why Dan got probably paid more than your normal, young law professor on a tenure track. Yeah. Wouldn't 180,000 be a fraction of what a Harvard-trained lawyer would normally make in the private sector? Yeah, maybe, but that's like something I've talked about in tons of other videos that not many people were interested in about the legal profession and the bimodal salary distribution and the lifespan of a big law associate. So Dan did work for a bigger law firm, Kellogg Huber, which is very prestigious in DC. But a lot of times people just dislike working for law firms. And that's why it was kind of bizarre that Wendi tried to make it sound like I got to go down to Miami to work for this law firm. It's going to be better for me and my kids. I'm like, really? Most people hate working for law firms. You have long hours,
right?
Billable hour requirements depending on the type of law you practice. You don't have that flexibility. If you have little kids, working for a law firm, it's not usually not a good choice, especially a bigger law firm. So so it's not necessarily true that if Dan had stayed working at that firm that he would then be making, over $500 to $1 million a year. Yeah, a lot of times people quit, or they're fired or laid off or told to, up or out. You're not going to make partners, so you might as well find another job.
I got the impression, really, and it's not that hard to fathom, being that they were both lawyers and they both had pretty decent credentials, right? She was no academic slouch either. She was pretty impressive, but it seemed like maybe she felt like it was a competition with him. I know when she spoke, she felt like she was being dissed by him, just disrespected, not taken seriously. He didn't read her book. And the little bit that she quoted from the book, I wouldn't have read it either. It wasn't that compelling. And, she's got a weird sense of humor, like with that latex thing and all that. It's just, but it felt like maybe she wanted to go to Miami and be a big shot lawyer and kind of make a name for herself, and she wanted to prove him wrong and was maybe competitive with him. I could see how that could happen.
Yeah, maybe a bit like that. And I've mentioned that's why at first when I heard about this case, I did feel some empathy towards Wendi Adelson, because I felt like that's kind of what happened to my legal career when I had to move from DC to North Carolina because of my ex-husband's job being a law professor, and his qualifications were a lot better than mine, so his career was going better and my career was going down the toilet, or no, I shouldn't really say that, but it really was a downer moving to North Carolina. But so do we believe that Dan was correct in that Wendi really did only have her job at FSU because of him? I would this is just my opinion based on someone that has some familiarity with law schools and the legal profession, but I agree, because she had just graduated from University of Miami, which is like a average ranked, middle of the road law school. Granted, I think she graduated with honors from University of Miami, but, normally, why would a law school want to hire someone that just graduated from law school to be even a clinical law professor? You have no practical experience. So, I'm pretty sure this was a job, kind of like a spousal hire, to sweeten the deal so that Dan would stay at FSU, since the dean really liked him and thought he was the superstar, and we better make sure he doesn't leave for, Harvard or some higher ranked school later on. So I do agree that most likely, if she weren't Dan's wife back then, why would she get this job straight out of law school or with very little legal experience?
I thought that too, especially they're going to pay him as much as they can in salary and make sure she has a job and do everything they can to keep him happy in Tallahassee. And I could see why that could annoy her too. But I don't know. Yeah. Tilo!
Yeah, thank you, Tony. Tony will be back again on Friday night, 7:00 Eastern time. So do not miss Tony returning. So don't worry, we can all take turns and everybody participate, But I really would like it if Tony would please be on camera on Friday. Yeah.
Please, Tony.
Let's see. I'm sorry. Yeah, let's just answer a few more questions and then call it a night because today is a work night, weekday, so it's almost an hour and a half. So, thank you, Ms. Pepper, and everybody. Who was driving a Honda when he could have afforded a luxury car? That was Dan, right? Yeah, Dan lived a simple life. Yep, he drove a Honda. The one that's in all those pictures where the glass is all shattered. Yeah. Oh, is Hooters good food, or at least I think it's okay. I really like the fried pickle slices. Have you guys ever gone there? The pickle slices are fried pickle, with a ranch dipping sauce. I love it, but I don't want to go to Hooters by myself. That would be really weird as a woman to go to a Hooters.
I've never been, and I never had a fried pickle.
Oh, you should go. Is there a Hooters around you?
I imagine. Yeah, I'm sure.
Well, you should go sometime for lunch, and actually there are families, like some people bring kids there.
Yeah, it's just a chain, right? Yeah,
I like the food. It's just that it's kind of embarrassing to go there, so I don't go there much, but I really wish I could just go there to eat the fried pickle slices and the boneless wings with ranch sauce or blue cheese. Yeah, it's so good. Yeah. Okay, she can say anything now, true or not. Dan is no longer here to defend himself. Yeah. Seems like the two of them barely knew each other when they married. Yeah. Wouldn't you know if your boyfriend ate kosher? Yeah, I think she knew that, but she was probably, they were just like a lot of people. You're kind of young and swept away and just happy to find someone that seems so great. And then you get married quickly. It was a long distance relationship most of the time. Yeah. Her words against Dan's now. I feel like every time Wendi opens her mouth and speaks about Dan, she is belittling him. It did seem like that when she was testifying at Katie's trials.
Even in the interrogation, that he wasn't even dead yet, and I couldn't stand that. The things that she was saying about him, and maybe he was a little. What they say, he lacked some
empathy, like he would rub people the wrong way and say,
right, but not. I mean, but they were asking who would want to murder. That's a little different. Yeah. She was not nice about him at all.
Mm-hmm. Yeah. Mm-hmm. Okay. Try pickle wheat thins? Really? I've never even heard of that. Okay, well, thank you. Okay, hi Stella. Thanks for being here. But I think we might as well just go ahead and end this since it's been well over an hour and a half. And, I got to get ready. Tomorrow's another work day and stuff. Yeah, thank you guys so much for your interest in the case. So like I said, on Friday night, 7 p.m. Eastern Standard Time, barring any unforeseen circumstances, Tony and I will continue going back to that Berkshire life insurance case that Charlie filed trying to get disability benefits. There was recently a summary judgment order entered by the federal court judge in that case, which should be pretty interesting to hear. So thank you, Dawn. If you want to hang on for a moment there, we can still keep talking a little bit, but we'll go ahead and say goodbye to all the people out there in YouTube land and really appreciate your support and caring about justice for Dan Markel. So thank you all for being here and participating. Have a good evening.
Bye.